Hi, good morning, everyone. This is Scott Giordano. I'm the host of today's presentation, Advancing GDPR Compliance, Post-Schrems 2 Using Data Classification. We will get started in about 2 minutes. We want to give an opportunity for everyone to log in. So be back with you shortly. Okay, let's get started. Again, if you're just joining us, I want to welcome you all to Advancing GDPR Compliance, Post-Schrems 2 Using Data Classification. I'm Scott Giordano. I'm Spirion's Vice President of Corporate Privacy and General Counsel. I am very pleased today to welcome Wally Bitaut. He is Vice President of Global Business Development at Seclore. Wally, thank you for joining us today.
Terrific. Thanks for having us, Scott, and hello to everybody.
Would you give us like a 30-second bio for the benefit of the audience?
Sure. I come from a security background, so the difference is really specializing in what we call data-centric security. So making the actual security perimeter the data itself, and I focus very much on trying to take that technology and blending it with others like Spirion, what I kind of coin the power of two. And then, bringing thought leadership around how two technologies together can really change the use and complement one another downstream.
Wonderful. Then without further ado, and just for the benefit of the audience, I've spent the bulk of my career involved in the law of privacy and security. So it's just a very apropos opportunity right now to speak with you, Wally, and to opine on the Schrems 2 legalities and really how that can be addressed by what we both do. So let's do this. Let's go over the agenda briefly. And I know that one of the questions I get is, will a copy of the slide deck be available? Absolutely, you will get a copy of this after the presentation. Also, if you have questions, please send them in. We love getting questions, and we'll just answer them as we get them. So what I'm going to talk about today in the first half of this is the GDPR and other mandates, but primarily the GDPR. And then I'll talk about the Schrems 2 decision and why do we care? This is probably the most important legal decision in terms of data protection that you likely have not heard of, unless you're a privacy geek like myself. Then I'll talk about this idea that came from Schrems of defeating intelligence agencies with technology, which I know sounds somewhat unbelievable, but we're going to talk about it anyway. Why and what is data classification and why do we care? And then Wally will take over and talk about modern digital rights management and what he likes to call building the electric fence. We'll dig deeper into the controlling the where, since that's a big component of complying with Schrems and potentially any other mandate that is similar to it. And we'll offer some closing thoughts and how to get there from here. So without further ado, let's do the following. Let's, if you would, leave with nothing else. We ask that you leave with the following. The GDPR requires technical and organizational controls or measures. That's to protect the traditional CIA triad. So confidentiality, integrity, access. It also adds resilience of EU personal data, which is interesting and could be the subject of its own presentation. The Schrems 2 decision really upped the ante for what the requirements are with respect to controls. Previously, the GDPR required that you had to have these reasonable and risk-adjusted controls. Now, Schrems 2 seems to have raised the bar on that. So we'll talk about that. We'll talk about the value of an audit trail and how using an audit trail for your data for regulatory compliance, including forensic details, whether it's the who, what, where, when, why kind of thing, that is going to be crucial to complying with Schrems. And then this capability, this complete revocation of access, or what Wally will tell you is the undo, or the ultimate undo button, anytime, anywhere, is a very powerful tool for completing the compliance circle. So that's what we're going to do. And let's get started with GDPR and other mandates. So it's interesting about the GDPR, and I get the question all the time. So Scott, can you tell me about Article 32? Article 32 is the information security aspect of GDPR. And I say, well, wait a minute, let's take a step back here. What about Article 5? Because Article 5, for some reason, I don't know why, but people tend to just skip right past it. And I'm not sure, but what's interesting about it is that it really has the table stakes for the GDPR and for any kind of compliance. So it has these 6 principles like transparency and data minimization and so forth, that you've probably already heard of. The 6th principle, so Article 5.1f, talks about protecting the integrity and confidentiality using appropriate technical or organizational measures. You're going to see that phrase quite a bit, in fact. And what I find fascinating is that when you look at all of the fines and penalties and so forth that are issued, Article 5 is almost always among them. So it's just interesting how it gets ignored, yet it is so important. And under Article 5.2, the idea that you have to demonstrate that you're complying with Article 5.1 is something that also gets lost in the shuffle. So that being said, there's also Article 32. So let's talk about that. So Article 32 is the main InfoSec, if you will, section of GDPR. So it talks about the idea of taking into account the state of the art and all kinds of other things, and that the controller and the processor shall implement appropriate technical and organizational measures to ensure level of security appropriate to the risk. So I've got everything in light blue that's associated with risk assessments. They don't tell you you need to do a risk assessment, at least in this case, but they're implying it. And because they say that you have to take into account all of these factors, the state of the art, the costs, the nature of the processing, the risk, all those things are part of a larger calculus. And they then will determine what kind of controls and how varied and all those kind of things are. And that's the nature between the two in Article 32. So also what's interesting is this idea of technical and organizational security measures are cited some 21 times throughout the GDPR. So even though Article 32 is the primary place you're going to find this, you'll also find that the idea is distributed throughout GDPR. Before I go on, if you have questions, again, send them on in. We are happy to address them. So let's talk about the Schrems 2 decision and why do we care. If you're not an attorney or otherwise a privacy geek, probably have not heard of Schrems 2, and that's okay. We're going to go into Schrems 2, and in fact, we'll go into Schrems 1 as well. So let's start off with this, though. The idea of transferring personal data out of the EU, whether it's to a country that's adequate or not, let's talk about it just in the abstract. So to get data out of the EU, you have 2 steps, and this is something that people consistently miss, is that you have to first have a legal basis to process the data to begin with. So for example, you may have a contract with that person. Maybe you bought something from a vendor, online vendor, and they need your shipping address, or they need your credit card, or what have you. So that's a contract. Or perhaps you're giving your consent to process your personal data. But there has to be some kind of legal basis. Otherwise, you can't go any further. And then the question is, okay, you want to transfer data out of the EU. Well, you've really got two big picture scenarios. you have this idea that if the destination country is adequate, you're pretty much good to go. And when we say adequate, what we mean and what the EU means is that the data protection in the target country is essentially equivalent to what it is or effectively equivalent to what it is in the EU. So for example, in Canada, that country is considered to be adequate. So they have a national data protection law called PIPEDA or PIPEDA. That's their federal level data protection law, and that's considered enough to get adequacy. So that's great. If you have adequacy, then you just transfer the data as per normal. However, if you are transferring data to a nation that is quote unquote not adequate, then it's a different matter, because then you need a data transfer mechanism. And certainly there are exceptions to this, but they're very narrow. By and large, you have to use this kind of data transfer mechanism. So it may be that you are using, or previously were using Privacy Shield, and I imagine many of you are familiar with that. Or you are using standard contract clauses, because that can take you anywhere. You don't have to necessarily use that just for transfers to the US. You can use it to any quote unquote inadequate country. Or you can use binding corporate rules. Binding corporate rules are much harder to get because you actually have to have them pre-approved, but they're basically standard contract clauses that are used among a collection of related companies. So maybe you have a parent company in one country and you have a bunch of subsidiaries all around the world, and you have this essentially intra-company binding corporate rules. It's like standard contract clauses, but just for those companies. Also, if you're a processor, you can do the same thing. So if you're processing on behalf of a third party, your customers, then you can also have BCRs, but have them as a processor rather than as a controller. So that's the basics of sending data outside of the EU. Here's what happened though, and this is probably one of the most momentous occasions in privacy, again, that many people either don't know about or don't realize the significance of. In June of 2013, you had the Edward Snowden revelations. And what happened is that Edward Snowden was an NSA contractor. He was privy to all kinds of things that the NSA was doing, and he believed that those things were wrong. So he revealed them to at least one, maybe three reporters at some point in June 2013. That created a huge stir, because largely the things he was revealing were very in-depth, and arguably they showed how the NSA had a very cavalier attitude towards personal privacy. They were plugged into the trunk lines that were coming into the US from the rest of the world and searching internet traffic. So that, not surprisingly, incensed a lot of people, created just a big commotion, if you will. And so what happened is that a privacy advocate, an attorney in Austria, Max Schrems, you've probably heard the name. Max Schrems essentially decided to go and fight this. So he went, and specifically with respect to Facebook and their transfer of personal data from the EU to the US. So he went to the Irish Data Protection Commissioner, because Facebook is headquartered in the EU in Ireland. And so we went to the Irish DPC and said, hey, this is wrong, I'm complaining. And that wound its way through the court system. It wound its way and eventually wound up at the Court of Justice for the European Union. And so what happened is that when that happened, the court looked at this and said, this is wrong. And they invalidated the Safe Harbor program. The Safe Harbor program was essentially what Privacy Shield was. Before with Privacy Shield, it was a data transfer program that was negotiated between the US Department of Commerce and the European Commission back in 2000. So it had been around a while. And essentially 15 years later, it had been invalidated by the Court of Justice of the European Union. It's the court, if you will, for the EU. So what happened? Well, the Department of Commerce goes back to work and with the European Commission, and they develop the Privacy Shield, which is a new and improved Safe Harbor. In the meantime, what happened is that when this invalidation happened, the Irish Data Protection Commissioner told Mr. Schrems that, oh, by the way, that whole Safe Harbor thing really doesn't apply to you, because Facebook didn't use Safe Harbor, they used standard contract clauses. So Schrems says, okay, fine, I'm going to go and take this back to court. So he starts all over again, goes back to the Data Protection Commissioner, and it winds its way through the court system. In the meantime, both the US EU Privacy Shield program is implemented and GDPR goes live. Because remember, it was passed into law in 2016 and had a 2-year grace period. So during this whole period, that goes live while Schrems 2 is winding its way through the court systems. So what happened is that in July of 2020, Privacy Shield was invalidated by the Court of Justice of the European Union, even though Mr. Schrems really wasn't, if you will, wasn't really interested in Privacy Shield, because at the time he had filed his new motion for his new case, Privacy Shield wasn't a thing. So he was going after standard contract clauses. So that's what happened, is that Privacy Shield got torpedoed anyway, and standard contract clauses were held to be valid, but there was some question about using them. So that's the Schrems 2 decision. And you say, well, why do we care? Well, I'll tell you why we care. So let's wind back to Schrems 1, and just bear with me here because I'll connect this all up. So Schrems 1, you have this idea that EU data that's coming to the US is subject to scrutiny on a generalized basis to US authorities, to the NSA and any other authorities, the FBI, all those folks. And there's no legislation prohibiting that. So that's an issue. And also, there's no remedy. So the EU data subjects can't go to US court and fight this whole thing. So as a consequence, the court in Schrems 1 said, sorry, Privacy Shield, I'm sorry, Safe Harbor is just not going to work. Not acceptable. So that's what did in Schrems 1. So rewind and go to Schrems 2. What happened? Same exact thing. They just gave more examples. So in this case, there's Executive Order 12333. This was essentially the order that was issued during the Reagan administration to allow sniffing of then just regular electronic traffic. So this is back in 81-ish. And so this is just regular traffic that's coming in to the US, whether it's through transatlantic cables or potentially anywhere else. You're giving essentially the intelligence community the ability to go search this traffic and see what's going on. And then there's FISA, the Foreign Intelligence Services Act, I believe, or Intelligence Surveillance Act, sorry, Section 702. This is a post 9/11 matter, and this was designed to legitimize U.S. Authorities spying on folks overseas. So combine these two, and then you've got a big problem, because there's no redress at all for 12333. Zero. No one, not even U.S. citizens can fight it. 702, potentially you can fight, but it's got a lot of problems. And then there's this Presidential Policy Directive 28, PPD 28, that essentially said, by the way, we'll minimize collection of personal data, folks, if possible, which didn't really help very much. So the court said, look, this is not going to work for us. You're going to need, if you're transferring data to the US, or really any country that doesn't have adequacy, you're going to have to add supplementary measures to ensure compliance with GDPR or whatever was going on at the time. Also, another way to say this is that you need to add additional safeguards, which again, I know all of this sounds redundant, but this is how they did things. So this is why when you see these phrases, supplementary measures and additional safeguards, this comes right from the Schrems 2 decision. Okay, so what's the upshot? Why do we care about any of this? So, well, first up, all data transfers from the EU to non-adequate nations, i.e. the US, had to be reviewed immediately. So there was no grace period. You just basically were stuck, as it were. So what you had to do is take a de novo review of all of your data transfers and determine, did you need additional safeguards or supplementary measures? Arguably, that would be the case in every case, because you likely established things that were not keeping in mind with whether intelligence agencies were going to search your traffic or just looking for regular bad guys. So that was pretty much going to be de rigueur, that you were going to have to add these safeguards or measures, and that transfers to the US would have to stop until those measures were put in place. Now, were they? That's a great question. I don't know, but likely that's the case. Also, Facebook just lost their appeal in the past couple months, and they must stop transferring EU personal data to the US. So you can imagine that if Facebook had this happen to them, it's not just a matter of time before others have this happen to them as well. So this idea of defeating intelligence agencies with technology, now that sounds just at first blush to seem ridiculous. So what's going on here? So what the CJEU sees is that the prospect of electronic surveillance by U.S. intelligence agencies on these transatlantic data transfers is such a threat to the rights of EU persons that apparently regular folks like you and I are going to have to implement measures to frustrate this surveillance. So you might say, well, that's great. What does that look like? Well, it could be stronger encryption, maybe. It could be pseudonymization, maybe, or tokenization here in the US. It could be just sending a hard drive over, shipping it over with, a FedEx box or something, and then uploading it here in the US, which is kind of clunky, but it could do that. So these things are options potentially, but they're not terribly helpful, simply because, and forgive me if I'm speculating here, but intelligence agencies are really good at breaking encryption. So I'm not sure how much good that's going to be. So suppose we took a different tact and said, okay, let's set up a data classification system that embeds in personal data just the limits on what you can do from an inadequate nation. Maybe some data, let's say that you send over 100% of your data, of which 1% is personal. Would you want to be able to just send over that 99% and screen out the rest that you can't look at? So the idea is, let's add data classification that can do that, and let's build an electronic fence that knows when someone residing in an inadequate nation like the US is trying to view someone's personal data, say in the EU. That's the prospect here, and that's what we're going to be talking about for the rest of the presentation here. So again, if you have questions, bring them in. While you're doing that, I'm going to talk about data classification. So this is something that I've worked on for probably the past 7 or 8 years, and I'd like to think that we've got it down to a science. So data classification, it's the process of analyzing a document or a file or some communication and then applying labels in the metadata that indicate what you can do. So who can access it, from where, how it should be, how long should you keep it, all those fun things. And you might say, well, what does that look like? Well, what it looks like is that you can see here, this is an example of a Word document, and it's got labels embedded into it that have different things. They have class 3, so proprietary and sensitive, because you're seeing social security numbers here. And then you've got different regimes that this data is subject to. So you've got GDPR, CCPA, Part 500 for NYCRR. So you can see you can have pretty much as many labels as you like embedded in a document or a file or a communication. So that being said, you can see what this looks like in the background. Essentially, if you took an X-ray view, what would this look like? You can see the code, how it looks, and then you can see the Part 500 and the other labels here as well. So that's kind of an X-ray, if you will. I'm going to pause here. Now I have a question. What about email transitions in global HRIS systems? We will, the net of it is yes, you can use data classification to protect things in conjunction with DRM. So we'll talk about that, and Wally will dig into that a bit. But yes, absolutely, you can protect email transmissions in global HRIS systems. Okay, so what is data classification and why is it valuable? I mean, it's valuable because it answers all kinds of questions that you're going to have anyway. So what information do you as a regular company have? Where is it? How is it controlled? How is it retained and disposed of? So it's a very critical part of your big picture information governance. It creates consistency in how controls are applied. So the idea that you would want individuals deciding on classification is wrong. You want to have one system that will decide on its own how things are applied. So that way you have a consistent application of the classes, and then controls are linked to those classes. And I'll show you an example of that in just a minute. Also enables organizations to justify the acquisition of controls, because you can say, well, this classification precipitates or implies that you have to have certain kinds of controls based upon whatever regime you're using. Say that it's ISO 27001, or maybe it's another of the NIST that is specific to your area. Maybe it's healthcare or what have you. The idea is that you're justifying particular controls because of the class and the risk involved. And then if there is a breach, then the question is, how do you prioritize? Well, it's great because you can always look for certain classes of data under certain regimes and say, give me all the data controlled by or governed by GDPR immediately and let me know how much there is. Great, now I can package that up and let the authorities know that, yes, we lost the HRIS database or something like that. I have a question about classifying structured data. Yes, can be done as well. So yes, that's entirely possible. Data classification components. Let me give you the four layers, if you will. So one is data classification matrix. I'll show you that in the next slide. So essentially, think about it as an agreement among the organization's stakeholders about what's the ramifications for a certain kind of data escaping. So if it's personal data here in the US, that's one thing. If it's personal data in the EU, it's an entirely another thing. So you'll have different classes. For example, I'll show you that in a minute. And then you'll have a policy, and a policy says it's our intention to govern data in a certain way, and we're going to employ the appropriate controls and policies, or I'm sorry, and procedures. And if it's violated, then someone potentially can be fired. Remember that if someone can't be punished, it's not a policy, it's just happy thoughts. Thirdly, you'll have tools like what we're talking about here today, like Spirion and Seclore. These are things that are going to implement this. So data classification tools are other things that help you manage your data classification system. And then monitoring and auditing. So think about what happens with SOX controls, where you have to make sure that they're functioning properly. Otherwise, there's no point in having them. Same thing here, you're going to have monitoring and auditing periodically to make sure that your data classification is actually catching all the things they should. So that's data classification components in a nutshell. Let me take you to a data classification schema. And so this is an example. This is a mock-up of a real one that I worked on some years ago. And so it's a very close to being the exact real thing. I just made some changes to protect the innocent. But this is a 4-class data classification schema. You can see for the yellow categories here that we've got personal data in non-US. We have PII that's HIPAA controlled here in the US. So you can see different things that are in class 3 that are potentially going to result in significant adverse impact if they escape. And so as a consequence, you're going to have certain controls like appropriate notices, secured in a locked cabinet if it's in paper. There's an entire list that's on the following pages that I can't share with you now, but that go into very great detail depending on the medium. So you'll have a control summary, but you also have individual controls. And that's important because those are the kind of things that are going to protect that class of data. You'll note that in the red category, you've got things like special categories of data in the non-US. So under GDPR, there's Article 9 special categories of data, and that's considered class 4 here. So it merits additional protection, like no transmission via fax. So that's in a nutshell data classification, how that works. Let me take a couple questions here because I want to just pause and address a couple things. One question I get a lot is the GDPR really being enforced? And the answer is absolutely. It's being enforced every day. There are several sites you can go to get a running total of all the GDPR actions that have taken place. Amazon got hit about 2 weeks ago by the Luxembourg DPA for about $750 million with a B, billion euros. So it's a serious offense, and I see companies getting hit almost every day with GDPR fines. So those things absolutely are taking place, and it is being enforced. The other question I get, and people are somewhat surprised by this, is that is it true that just looking at personal data is a transfer to another country? And the answer is yes. So if I'm here in the US and I access data on a server of EU folks in the EU, so it's EU data subjects, and I'm looking at it, even if I don't download it or copy it or anything, just my eyeballs on it, that's a transfer of information. If I have the HR director in, say, an office in London, or in any other country in the EU, talking to the HR director in New York, perhaps, about a troublesome employee and about how the employee has a drinking problem or something like that. It's transfer of personal data from the EU to the US. Even though it's verbally, it's still a transfer. So it's very easy to transfer data from the EU to US without realizing it. Secondly, or thirdly, I have here, will using the new standard contract clauses make me compliant for transfers to the to the US from the EU? And the answer is maybe. It still depends on what kind of technological measures you're putting in place. So those clauses alone will not help you. You'll still need to dig in and make sure that you have the appropriate controls, which is the subject of our discussion today. And then finally, will there be a replacement for Privacy Shield? And the answer is almost certainly there will be a replacement. The problem is with it is that I don't see how it's going to fix the problem, because until the US makes big changes to how we address intelligence gathering, what have you, I just don't see it. So this is just something that, again, a question I get a lot. I think they will, the European Commission and the US Department of Commerce will come back with something at some point, but I suspect it's just going to get challenged again and get shut down again. So that's it. Yes, someone just sent the GDPR enforcement tracker. Yes, thank you for that, by the way. I was going to mention it, but thank you for doing that. So if you go to www.enforcementtracker.com, you will get a daily download, if you will, or a daily running total of all of the GDPR fines. And like I said, they happen either every day or almost every day. Some DPAs are prolific. The Spanish DPA is usually putting out one fine every other day or every 3 days. And it's very interesting to take a look at that. The Italian DPA is maybe putting out once a month, but they're typically big. Sometimes 2.5 million euros, sometimes 1.5 million, but they're typically big for that. And then there's just everything else in between. So it's remarkable that you'll see that. And so if you have not had a chance to look at that, it's the enforcementtracker.com. Definitely take a look at that. So thank you for that. I'm going to switch gears here, and Wally, I want to turn this over to you and talk about this idea of modern digital rights management and the concept of building the electric fence.
Terrific, and thanks, Scott, for that. So now that we understand the problem and we understand how to identify the data that causes the problem, I'm going to focus on how do we address the problem. And so when we talk about building the electric fence, it certainly implies technology to do so. So let me start with what I like to refer to as the power of two. And really, it's best of breed solutions, specifically Spirion and Seclore, that creates what I like to coin this data-centric security lifecycle, which is discover your information, classify it based on the classification, protect the data. And once the data is protected, you now can analyze how your data is being used. So this data-centric security lifecycle, the beauty of this is that it is completely automated. We've taken the user decision out of the equation. So how do we get there, and what's the ease by which we can get started? And so I'm going to talk a bit about Spirion's workflow playbook, which is the mechanism by which we can basically build business rules or decision trees to determine how to identify data and what to do once we identify it. And so in this case, we can start with a predefined template. This example is dealing with personal identifiable information. And this personal data, step one is the question is it personal? And if it's not, we can simply ignore it. But in the other case where it is personal data, now we want to create a second decision tree, which in this case is it subject to GDPR? If it's not, we can simply classify it as proprietary or sensitive, and perhaps we put a protection layer around it that allows this information to only be viewable for the next 30 days. If the GDPR, if it is subject to GDPR, now we get into this electric fence. And so now maybe we want to ask another decision tree question: is it special personal data? If the answer is yes, we can certainly classify it a specific way, and again, put a certain encryption encapsulation around the information where in this case it's viewable, but it's only viewable within 2 different countries. And if it's not, we can classify it a certain way and give it yet another type of policy. So what I'm starting to talk about here in this Seclore squares is something that refers to rights management, where we're creating policies about the information and how it can be used based on classification tags. And so let's delve into what rights management really is. It's information rights management, digital rights management. Ultimately, it refers to data-centric security, where we are answering 4 questions about your data. So the first is who? Are you the right user or group of users who should even access this information? So step 1, check. The second is if you do have accessibility to this information, what can you do with it? Can you just view it or edit it, print it, copy and paste, take screen grabs, work offline? So it really is very granular usage controls about the information that you're viewing. The third is a time-based element, the when. So, great use cases, relate to like M&A, where you're sharing information of financials, et cetera, sharing audit information. You want it to basically expire at some specific time. So we have the concept of time bombing. And then last but not least, which is very relevant to the Schrems 2 case, is the where, which is the geolocation or geofencing that can occur, where we can only ensure that this information maybe is available in the EU, as Scott mentioned, but not if it arrives here in the US. So these are the very, very granular controls that stays with the information anywhere it travels. And this is really one half of rights management, which is the policy protection and enforcement. The second half is the auditability. So anything that is protected is now auditable. So in this simple example, you have a dashboard that shows how your data is being used. The red circled items happen to be activities that were not allowed. So unauthorized activities, although they were blocked and stopped, they were also logged. So we know what's happening to this information outside our corporate network. And we can provide very forensic details about the information, its classification tags, how long users have been on the document, the location of the document, IP addresses, name of files, et cetera, et cetera, et cetera. And from a high level, we can also provide trend analysis. So now from a corporate perspective, you can see data which has left the building, and you can have some idea of kind of the trends of activities that are happening against your data. And from there, you can drill down into that forensic data I showed earlier. So let's get into the controlling the where as it relates to, now that we understand what digital rights management provides and the 4 Ws. And so let's take a look at what the current situation typically is in a typical organization. We have our typical enterprise network. We have firewalls that surround it. We have cloud applications that we're leveraging. And we likely have some set of tools that are used to try to govern that information. In reality, what's happening, however, is information is getting shared outside of those containers, so to contractors and partners and to auditors and even our own internal employees when we think of COVID, who are not within our 4 walls, or perhaps just mobile. Any of those types of activities is sharing data outside of the controls of the perimeter-based solutions. And what really this creates is what I like to call the last mile problem, where you simply are not protecting the data when it leaves the perimeter. So you have lost security, visibility, and compliance. And really what you've created is a strategy that is based on trust and legal controls, right? Is my contract going to support me, my NDAs, my audits, et cetera? And that's really what the current situation looks like for many organizations. Now, let's go forward with this best of breed power of 2 Seclore and Spirion and take that same model where, again, we have our corporate network with firewalls and cloud applications. In this case, we layer on Seclore and Spirion. And now when data is being shared, it's being shared in a secured manner. So nothing leaves the confines of the organization, the cloud applications, going to a mobile device without it being fully protected with the 4 Ws that I mentioned earlier. And what this now does is it creates this compliancy around the last mile. So it's completely visible and it's secure. We even can see, as I showed in in the audit trails where we can see unauthorized attempts if someone's trying to breach and impose access to a particular document. And in this case, we now have created a zero trust environment. Information is now leaving the organization always in a secure manner. So let's take this and apply it directly to the Schrems 2 and GDPR use case. So here we have our basic corporate network. In my simplest example, I have a single document that needs to be shared. And it needs to be shared outside the organization. And it doesn't matter how it's being shared, email, cloud applications, etc. But we want to share it to multiple, potentially countries, users, wherever they might be. But we want to ensure that only the right people have access to it. So when we talk about the 4 Ws and specifically the where, we can ensure when this document leaves the enterprise that only the right countries have access to it. So this electronic fence. And if for some reason it ends up in an inadequate country, in this case, the US, that access is denied. And so all of this happens with a complete audit trail to prove what is happening with your data. So with that, I'll turn it over to you, Scott, to kind of close it up.
Sure, wonderful. If it's okay, if we can take some questions here that have come in before we wrap things up. One question is, how is your solution, presumably it's you, Wally, how is your solution different from an encryption solution?
Sure. And I get that question all the time because encryption is actually a part of the solution. But encryption is not enough. Encryption is really black and white. It's on or off technology. If I send something to you, Scott, encrypted, I need to make sure I share it with you with the key. And once you unlock that, I no longer have any control of what you're doing with the information, and I have no visibility into what you're doing. And so the difference is that rights management is really encryption on steroids, right? You take an encryption, you think of encryption at rest and in motion. This is encryption in use. So while the documents are still encrypted and being accessed, we are still controlling the 4 Ws, as I mentioned earlier.
Okay. I have another question. It says, as a recipient of a protected document, do I need an agent or plugin in order to consume the document?
So the answer is no. So one of the concerns that we've seen, and that question is spot on to that, is that there's always the balance between security and usability. And certainly if I'm sending out protected content and information and the recipient has to jump through some hoops and has to download, agents, in many cases, they might be black or whitelisted, so they simply can't do it, or they might need administration help to do that. All of that simply stops the flow. So we've got the silver bullet, which ultimately allows the recipient of a protected document to consume it using any browser. So it doesn't matter, where the location is. Any browser can now consume that, and we continue to control the 4 Ws mentioned earlier.
Wonderful. One final, well, maybe not final, but one final question for you. From a compliance perspective, can you revoke access to a document even after access has already been granted?
Yes, that's the beauty of it. So when we protect a document, we ultimately wrap it with encryption, and we store keys separate from the document itself. And those keys can live, on-premise in your environment or any hybrid or private or cloud type of environment. And by basically providing the keys separate from the document means at any point in time, I can change the policy. So I can give you read, view, edit privileges today, and tomorrow I can say, I am only going to let you view the document. And the next day I can say, you know what, I can see you're doing some authorized things that I'm blocking. But I'd like to simply revoke access. So, when you mentioned at the beginning a key takeaway, at any point in time, you have the ultimate undo. You can simply block the data so it's no longer accessible, regardless of where it exists, regardless of how many copies it has, regardless if it's gone from, Word to PDF or any other file format. We can remove all copies post-distribution.
Wonderful. With that, let's close this up and then talk about how to get there from here, as it were. So, with respect to the Schrems 2 decision, again, this is probably the most important decision vis-a-vis privacy, at least international privacy, that you likely haven't heard of, but it's still enormously impactful. And it's impactful right now. Geofencing substantially addresses this mandate of supplemental measures, because the idea of being able to granularly control all the aspects of looking at a document or whether it gets looked at and from where and what have you, previously not easy to address, now it is. Also, this idea of employing automation, enabling scalability to the data protection model. It has the where, the discover, classify, protect. Essentially, you're keeping the user out of the equation. And let me qualify that. I'm a big fan of having a committee, like a data protection committee, set the standards, but not allowing individual users to determine whether they can see something or whether something is of a particular class. That's something that is really, in fact, detrimental, because you're creating inconsistency, and I mentioned earlier that you want consistency. And then finally, once content is protected, not only is the risk been averted, but you can also demonstrate compliance. And I think you all remember from earlier in the discussion how that you have to demonstrate accountability. That's section, or Article 5 rather, the second part, so sub 2. Those are the closing thoughts. I know we just got another question in, Wally, and it's for you. It says, we are standardizing on sharing via 365. I presume that's Office 365, using links to specific individuals. Our existing DLP solution would not search this data as it's going out. Does your solution address this?
Yes. Oh,
yeah.
sorry. Go ahead.
Go right ahead. This is great.
Yeah, I was going to say, yes, it certainly does. I mean, we've seen the real flow of organizations moving more and more and more to the O365 platform. So we definitely had a strategy to ensure that we can protect that platform in its entirety. And now we can make Microsoft secure, and whether that's SharePoint, OneDrive, Teams, email, any of those types of environments, we work with those to ensure that when data leaves those platforms, that it always stays protected. And we take it a step further in that we still keep Microsoft's policies in control, something that we coined policy federation, which is exclusive. And what this basically means in a simple example is, if I downloaded something out of SharePoint to my desktop, it will phone back home to SharePoint every time it's accessed, whether it's at that desktop or if it's emailed downstream to somebody else. Every time that document is opened, it will phone back home to SharePoint to say, what can I do? And in an example where maybe I'm a contributor, the first time I open it, I can view, edit, and print the document. And then someone changes something in SharePoint, and now my role is a viewer. The next time I open that same document outside of SharePoint, now I can only view the document. If I'm offboarded as an employee, when I go to access all those documents maybe sitting on my home PC, they're no longer accessible. So long answer to that, which is yes, we have a complete platform integration with the O365 platform, yet we make it simple so that all of the hard work you did in defining your security policies in Microsoft doesn't get lost.
Wonderful. And just for me to add on to that, if I may, there was a mention here of your existing DLP solution not doing that. Essentially, the technology that Spirion provides that brains, if you will, for DLP. So now when DLP sees labels that are in the metadata, or alternative data streams, we'll look at that and go, okay, now I know what to do. So that's one of the challenges with DLPs. Until you put brains into it, it's not going to know exactly what to do. It's going to be very hit or miss. So yeah, it's a great Spirion Seclore solution. Another question that just came in, Wally, I know we have a few minutes left. This is a great question. So from a compliance perspective, is it considered a data transfer if a trusted IT system administrator here in the US is required to access GDPR personal data in order to archive it or destroy the data? I recognize access equals transfer. I'm wondering if there's been any exception allowed for IT systems administrators. The answer is no. And this is something that drives attorneys like myself nuts, because you may have a relationship between two sides of the Atlantic. It may be the same company, but two different divisions, or it may be two completely different companies. But even if there's a theoretical opportunity for someone in the US to look at data in the EU, then arguably it implicates GDPR rules, and therefore you need that additional protection. Even if as a practical matter, you're not going to be looking at the data, you're just going to be moving files. Unless there's a way to prevent you from looking at the data that's in the files, then there's really no way to get around it. And so these are one of these 99% cases that drive me nuts as an attorney, because if it was 100%, then it makes things easy. But that one little opportunity then creates a necessity to work around it, or to find some contractual way to address it, or a technical way or something. So yep, this is exactly why you need data privacy attorneys. So that's the last question that's come in. I'm going to go to talk about how to get there from here. So you have the opportunity to, and Wally, please help me on this. You have the opportunity certainly to deploy this on-prem or in the cloud. Is that correct?
Yeah, that's exactly right. I mean, there's still folks that have some nervousness about things off of premise. So we provide any combination, on-prem, in the cloud, hybrid, which gives you a lot of flexibility based on what your concerns and strategy is. Okay.
Would you hit some of the rest of these? It sounds like that you've got the big picture here.
Sure. So, as I mentioned earlier in walking you through the playbook, Seclore and Spirion have been working tightly so that our two offerings blend together. So it's not like there's an integration requirement. You can simply turn it on by using the playbook as I walked you through, and you can start with a template, if you will, but they're very easy to create. The decision trees are simple, and one of the decisions now has become protection, or what I like to coin Seclore it for protection. So basically you can use the playbook to identify the data, to classify the data, and to protect your data in a very simplistic manner.
Excellent. Before we go, I just want to do a shameless plug for Spirion's Privacy Please podcast. I think it's consistently cited as probably in the top 3 of all privacy podcasts. So they have a great team working on that, and all kinds of guests. So please do have an opportunity to listen to that. And we have a takeaway document for you. You can see here that you should be able to click on now or after the presentation's over. If not, when you get access to the slide deck, you'll be able to get it as well. And if you have questions, you feel free to email me or Wally. I'm happy to answer questions. I can't give legal advice, but certainly I'm happy to give you what I think is the case. And I'm sure, Wally, you're happy to answer questions as well.
Sure, and I'll give legal advice all day. Just don't ask me.
Hey. Wonderful. That's it. We've run out of questions here, and we have a couple minutes left, but I think we'll wrap this up early. Wally, this has been delightful, so I'm very glad that you were able to join us today, and I hope that we can do another one of these, because I'm sure we'll have follow-up questions that'll probably precipitate some more ideas.
Terrific. Yeah, thanks for having us. Hopefully this was helpful to the audience out there.
Wonderful. Thanks for joining, everyone. We'll see you next time.